Department agencies subcommittees now in session. Today's Tuesday, March 9th, and it's a little bit after 3, but had to wait on a few members to make a quorum. Lisa, please call roll.
Vice Chair Kiesling. Beck.
Here.
Bricken. Carr. Carringer. Chisholm. Holford. Chairman Holsclaw.
Present.
Chairman Holsclaw, we have a quorum.
Okay, we're going to do a little housekeeping on the calendar here to get everything aligned properly. And then we don't want to waste anybody's time for waiting on a bill, so we'll get you up to date on everything. House Bill 841 by Williams has been rolled 1 week. Item number 8 on the calendar, HB 0439 by Griffey, has been rolled to the last committee calendar. Item number 11, HB 1374 by Carr, rolled 2 weeks. Item 14 on the calendar, HB 1415 by Boyd, is rolled 2 weeks. Item 15, HB 464 by Littleton, rolled 1 week. Item number 16, HB 426 by Littleton, rolled to the last committee calendar. Item 17 on the calendar, HB 241 by Ramsey, rolled 2 weeks. Item 18 on the calendar, HB 921 by Ramsey, rolled 2 weeks. I know that sounds like a lot, but we still got a lot to do. And what I'm going to do, we're going to take 2 items out of order, and that's item number 9 and number 10. Deputy Speaker Johnson.
Thank you, Mr. Chairman.
And we have so now the bill's properly before us, HB 0348 by Chairman Johnson. You are recognized.
Thank you, Mr. Chairman. House Bill 348 has an amendment.
Okay, what's the amendment number you got?
It's drafting code 4224.
You got a motion second, so it's properly before us. Can you explain the amendment?
Yes, Mr. Chairman. The amendment makes the bill. House Bill 348, as amended, helps make certain that everyone applying for a liquor license, retail liquor license, must comply with the existing law, which requires financial responsibility. This bill requires that each applicant must be current on all payments for taxes, lease payments, loans, payments to vendors, and the ABC may require applicants for the license to certify via affidavit that each of these requirements are met. It is imperative that the people who sell alcohol are financially responsible and not incentivized to break the law for financial gain. Recently, we've seen instances where liquor by the drink owners have shut down businesses without paying debts or taxes, only to receive a new liquor by the drink license through the ABC. So that's what this bill does.
Thank you, Chairman. Any questions, comments on the amendment? You're recognized, Representative Beck.
Thank you, Chairman, and thank you, Chairman Carr, for withdrawing your question on the bill. Just very quickly, this seems like such a no-brainer. Is this just something that has been overlooked in code?
Yes.
Very good. Thank you.
Thank you. Any other questions, comments by the committee? Questions been called on the amendment. We're voting on amendment 4224. Those in favor say aye. Aye. Those opposed? The ayes have it. Amendment goes on the bill.
Thank you, Mr. Chairman. Committee.
Questions been called on the bill. We're voting on HB 348. Those in favor say aye. Aye. Those opposed? Bill moves on. Where's it going? It's going to full committee. So congratulations, Chairman. And
Thank you, Mr. Chairman. Committee.
we get to see another HB 866 by Chairman Johnson.
Thank you, Mr. Chairman.
Got a motion and a
Mr.
second.
Mr. Chairman, there is an
We have an amendment.
that
What's-
makes the bill
What's your drafting code on that?
4085.
Okay, 4085. You want to, got a motion and a second? You are recognized, Chairman.
Thank you, Mr. Chairman. House Bill 866, as amended, pertains to the delivery of alcohol from a retail package store. The delivery of alcohol from a retail package store is legal in Tennessee today. All this bill will do for the delivery companies is to operate under a percentage basis, a percentage-based business model if they choose to. As it is in today's law, they're under a fee-based. Now, if you're delivering groceries or food or anything from a restaurant, that's on a fee-based. But alcohol is on a flat fee. So this would not prevent, it's permissive for those businesses. If they want to be on a flat fee, they can. But if they choose to go on a percentage, this would allow them to do it by a percentage, capped at 10%. And this will allow companies to decide which business model that they would like to operate under.
Got a motion? You already got a motion, second on the amendment. No. Call for question on the amendment. Question's been called on the amendment. Without objection. Those in favor say aye. Aye. Those opposed? Amendment goes on the bill. You are recognized. Chairman Johnson.
Thank you, Mr. Chairman. The amendment made the bill, so.
We've had a request for testimony. Will you draw your?
I will, Mr. Chairman, I'll withdraw that.
Thanks, sir. We'll go out of session to hear some testimony by Brian Bivens. We're out of session. Okay, you don't need to speak?
Only if there's a question.
Okay. We're back in session. Question's been called on the bill as amended. So we're voting on HB 866. Those in favor say aye. Aye. Those opposed? Bill moves on to full committee.
Thank you, Mr. Chairman. Committee.
Now we're rolling back to item number 2, HB 0796. That's Chairman Howell.
That would be me.
You've got a motion, second? Second. You are recognized on HB 0796, Chairman Howell.
Thank you, Mr. Chairman. This bill was brought to me by the Department of Treasury. I'm glad to have Treasurer Lillard with us in the audience today. He's my backup. As background for this bill, I might let the committee know that it is the responsibility of the Department of Treasury to settle any tort claims that come against the various departments of Tennessee. That even includes the institutions of higher education, TDOT, Department of Health, any tort claims that rise against them. Treasury settles those claims. As an example, a minor example, since I chair transportation, I can give you this example for the benefit of the committee. If a driver hits a pothole on I-75 as you go home from session, and it's an 8-inch deep pothole, and you damage the front end of your car or blow out your tire, you actually have access to make a claim to have your tire replaced. And a lot of people don't know that, but if approved, if your claim is approved, then you can get a new tire. In order to process that claim, though, the Department of Treasury must investigate, which includes getting a response from the department that the claim is lodged against. And the Treasury bylaw has 90 days to settle and clear the claim by either approving or denying it. The rub comes when the department involved in the claim cannot or does not respond in a timely manner. And as I said, the department only has 90 days to clear this claim. So if a department doesn't respond, let's say waits 75, 85, 89 days, I think, which is what happened, then the Treasury Department doesn't have enough time to clear the claim, and the claim by law is denied. That's not really fair. So what this bill does, the department would like to create an incentive program. And this bill gives the department the authority to create the incentive program. This bill does not create the incentive program. It gives them the authority to do so. And since it's an interagency relationship, the department board, I believe, would be creating the incentive program. And I'd be glad to try to answer any questions that the committee may have, but that's the essence of the bill.
Do we have testimony, or you just?
I don't know, Mr. Chairman. I don't know.
Okay, questions, comments? You're recognized, Bricken.
Thank you, Mr. Chairman. And Representative Howell, we've talked about this bill, and I certainly will support it. My observation still holds that I think I've shared. It seems like the governor's office, if he has a department that is not doing their job in providing reports timely, as chief executive, he should be able to take the action to speed that process up to the satisfaction. And we don't need some incentive quote system to do it. I mean, that's the way you run a business. So that's just a statement.
You're recognized, Chairman Howell.
I don't disagree, Representative Bricken. Fortunately, the Treasurer's Department is a constitutional officer which is appointed by the legislature, so the legislature is taking the initiative to create this incentive program so that we can run a more efficient government and be more responsive to the people of Tennessee. So that's why we're bringing the bill.
You're recognized, Representative Beck.
Thank you. And myself, like previous representative, I'm going to support this, but I was curious, what type of incentives are we going to give the departments? They can't win like a trip to Hawaii or, what incentives do you give a department to have them do what they should be doing anyway?
You are recognized.
I certainly can't speak for the department because the program hasn't been created yet, but in discussions, the things that have been discussed have been monetary incentives, and I assume there would be benchmarks. If you respond within 10 days or 15 days or whatever, you would be incentivized. And the fund that already exists is the risk management fund, out of which the claims are paid. So I'm assuming that they would incentivize them some way to their budget out of the risk management fund if they are efficient and respond in a timely manner. Also, on the other hand, if they do not, there would be a stick to the carrot and stick program, which would probably incentivize some deductions from their budget.
Very good.
Those are discussions. I'm not saying that's on the record that's what they're going to do. I'm just saying those are discussions that have been held.
Very good. Thank you, sir.
Other questions, comments? Seeing none, we are voting on HB 0796. Those in favor say aye. Aye. Those opposed? Ayes have it. You're moving on to full.
Thank you, Chairman and committee.
We now have HB 1227 by Chairman Reagan. I see him back there. Do we have a motion and a second? Second? Bill's properly before us. You are recognized, Chairman Reagan.
4371.
Okay. Thank you. Do I have a motion, a second on the amendment? You explain the amendment, Chairman Reagan?
Thank you, Mr. Chair. Basically, this amendment is adding to the bill. It's a bit disjointed without having seen the bill first, but what this amendment does is provide the opportunity for complaints, and it also provides that someone who suffers damages from a public or a monument that they have can claim or make a claim in court for those damages. Now, I can go into greater detail on this, but essentially that's it. The last section of this adds a portion in here that says the monuments or statues that are on the second floor of the Capitol cannot be altered, removed, or concealed or obscured without approval in accordance with this section, and that refers back to the first part of the bill, which I can go over in a minute. The teeth in this is the last bit of this. It's a Class C misdemeanor if the offense is committed by an elected official and in violation of impeachment. Violation is an impeachable offense and grounds for ouster. That's the amendment in a nutshell, sir.
Okay, we're voting on, any questions, comments? We're voting on Amendment 4371. Those in favor say aye. Those opposed? The amendment goes on the bill. You are recognized again on HB 1227. Please explain the bill, Chairman Reagan.
Thank you. The amendment enhances the bill. But first off, let me say that Tennessee has a deep and rich history all the way from Mountain City to Memphis, and Tennesseans across the state support and recognize the importance of our history. The bill before you today strengthens and further protects the preservation of Tennessee history. To this point in time, the legislature has not had a direct role in selecting members of the Tennessee Historical Commission. This bill corrects that problem by dissolving and reconstituting that commission so that the appointments are now spread between the governor, the Speaker of the Senate, and the Speaker of the House. This gives the General Assembly, which has close contact, of course, with all 95 counties, the people of Tennessee, the opportunity to be involved in getting members on that historical commission. And additionally, the portion that I just read to you as an amendment allows for any of these monuments that are removed to be put before the Tennessee General Assembly for final approval. Now, the bill is not that long. I probably spoke more than I should have on it. But the guts of it is to put the General Assembly in the loop. Right now, the governor makes all the appointments to the Tennessee Historical Commission. And I and a number of others think that, like many other of our commissions, we should have a balanced selection process between the Senate, the House, and the governor. With that explanation, I stand ready to answer questions.
Okay, the first question I would have, the Historical Commission has total control right now, is that correct?
For all intents and purposes, yes, sir.
Okay. Other questions, comments? You are recognized, Representative Beck.
Thank you. Chairman Reagan, in reading this, I don't have any problem with the reshuffling of who chooses who. First of all, and help me understand this amendment with, it makes the person financially liable for any damage, which is understandable, which is present law anyway today. But the question I have is a criminal penalty. Tell me what you're getting at. What is your thought with this adding a criminal penalty to protect? And it looks like it's just limited to the bust on the second floor of the Capitol. Is that correct?
No, that's a separate section, sir.
Separate section. Okay. Well, explain to me where you're.
The idea behind this is, as I'm sure everybody in this room has noticed, there was a statue out on a pedestal in front of the Capitol building that is no longer there. It was damaged beyond replacement. What we're going to do with that as the General Assembly will come later. But the idea behind that is that that should be criminal. Now, and some would argue that destruction of public property already is, but this clarifies it and makes it patently clear that the offense is in fact a Class C misdemeanor.
You're recognized, Representative.
I would, I think this is redundant because it obviously is already a offense. Legal, can you help us out on that? Or could we got a session here from legal
Yeah.
on that, please?
Let's go out of session and hear from legal.
Could you just re-articulate the question for me?
The question is, the sponsor is trying to make a Class C misdemeanor for the destruction of a monument or a statute. And my question is that not already a criminal?
I would say yes and no. I would say in its application, if you looking down towards the end of the bill in subdivision 3, it says a violation of subdivision, it's got a blank, and then 1A and blank subdivision 2. And then you look back up at 1A, it's regarding the removal, concealment, or obscuring of a privately owned monument, plaque, marker, or memorial. Currently, the Historical Commission has jurisdiction over publicly owned memorials and monuments and plaques. This brings in privately owned memorials of historical significance. And I think in that context, a private citizen would have a cause of action for damage to his personal property. With respect to the statues that are public property on the second floor, there's some additional activities that are being captured here, like the concealment or obscurement of the statues without approval in accordance with this section. That would also apply, the Class C misdemeanor would also apply to those activities, and I'm not sure that would be captured by any existing provision of law. So in that sense, I think it may be an extension.
Is, when you say, okay, so the extension would be to the part of the amendment that says unlawful to conceal one of these statues on the third floor. Am I following you correctly?
Yeah, I think so. Conceal and obscure are the two that jump out at me in terms of what's in the Heritage Protection Act. You can't alter or remove one of the statues without getting a petition approved by the Historical Commission.
And what's the definition of obscure?
That's a good question. I mean, I would say that if it's not defined, you give it its plain and, as you know, as an attorney, you give it its plain and ordinary meaning. So if you cover it up or block it in some way that's, from the public view, if someone would try to put something over, cloth over a monument or a statue, that would be obscurement or concealment. I'm not sure that there's, I can articulate the difference between concealment and obscurement. Now, see, the sponsor there has a comment that might help offer some clarity.
If I could, Mr. Chair, the bill is aimed at
Hang on, are we through with discussion here? We're going to go back into session.
for the
Your
lawyer.
attorney? Okay, you are recognized, Representative Carr.
Thank you, Mr. Chairman. To the attorney, Mr. Mundy, when we added that amendment on, did that rewrite the bill?
No.
Or did it just add to it?
You are? We're still
Matt
in
Money from
session.
legal. This amendment rewrites the bill. If you look at the top, it deletes all language. I'm looking at drafting code 4371, and it deletes all language after the enacting clause and substitutes instead the following, starting with section 1.
Okay, we're going to go back into session. You are recognized,
Mr.
Chairman
Chair,
Reagan.
that was an error that I didn't catch. It wasn't intended to rewrite it. It was intended to add to it. So with that, I will volunteer to take it off notice and fix that. To answer the question about concealment, though, before I do that, there was an incident where an individual dumped a load of dirt over a monument and covered it up. Otherwise, it wasn't damaged. So this is intended to prevent that. Also, private monuments, if I could clarify again before I take this off. In the district next door to mine, I officiated a ceremony of the Daughters of American Revolution. They put a monument up in one of the historic churches in this district celebrating the cemetery there, which had Revolutionary War soldiers buried and their families there. And this monument was put up there. It's a privately owned monument. It doesn't belong to the state. So this is intended to capture that. So, Mr. Chair, because I screwed up on this, I apologize. I'll take this off notice and get that amendment fixed.
HB 1227 is off notice.
Thank you.
Thank you, Chairman. We're now moving on to item number 4, which is HB 0173 by Representative Manis. You are recognized, sir. The bill's properly before us. You are recognized.
Thank you, Mr. Chairman. Thank you, members. House Bill 173 requires the Emergency Communications Board to develop a statewide implementation plan addressing text to 911 service. Requires all local emergency communication districts to provide text to 911 services by January 1st, 2023. As of May 2020, 11 of Tennessee 911 stations are ready to implement this, and 38 are in progress to launch. Some examples of opportunities that you would have to text 911. It would be beneficial to a lot of different people, people with speech and hearing impairments, disabilities, medical situations like allergies or strokes, victims who have been abducted, domestic violence victims, human trafficking, along with school shootings. Currently, 17 other states that have texting 911 are Indiana, Alabama, Vermont, Colorado, Georgia, Illinois. The list goes on and on. And so the technology is currently available through the Next Generation platform. And this is basically just trying to set a statewide standard to be implemented by January 1st, 2023.
Okay, do you have testimony?
We do have Josh and Molly Anderson here that will testify.
Okay. We'll go out of session to hear that testimony.
Thank you.
If you would, please state your name and who you're with, clearly, so we got you on record.
Hi, I'm Joshua Anderson. I'm a third-year law student at the University of Tennessee College of Law, and this is Molly Anderson, and she works with the Arc of Tennessee.
Glad to have you.
And she has a brief statement. She's going to play it on her phone here and then also sign it so you all can understand. Ready? Great.
Hello, Chairman Holsclaw and House Subdepartments and Agencies Committee members. My name is Molly Anderson. I've been a Tennessean for 7 years, and my husband and daughter on the way call Chattanooga home. I have a disability called apraxia in which I cannot talk, but can hear perfectly. Here is why House Bill 0173 is so important to me. When I was a senior in high school, I got into a wreck and could not call 911. I spoke in front of the local city council meeting on Senior Government Day about texting 911. Well, 6 years later, I crashed again, this time into a funeral hearse, believe it or not. Thankfully, no one was hurt. Though the casket got dented, the dead guy was okay. Again, I wasn't able to contact 911. When I FaceTimed my husband, he could not understand me because I was crying pretty hard, and my signs were everywhere. A sweet bystander phoned 911 for me. It is really scary when I can't get help. Texting 911 can help so many others who cannot call 911. Let's make Tennessee better together by allowing texting 911 statewide.
And I'll just briefly mention as well, with my work with the legal clinic, working with domestic violence victims, if you go to an order of protection docket, just about every week, there'll be examples of cases where victims would have de-escalated the situation, or frankly more arrests would have happened if they were able to text 911 instead of calling or not being able to call in the first place. So we'd be happy to answer any questions if you have them.
Does the committee have any questions for these individuals? I definitely appreciate you all coming, and great job about having our fingers tied all together, trying to do all you did. But we thank you for your testimony. We'll go back into session. And you are recognized, Representative
Thank you,
Manis.
Mr. Chair. I am happy to entertain any questions about House Bill 173.
Representative Bricken, you are recognized.
Thank you, Mr. Chairman, and Representative Manis. I'm certainly fully support the concept of the bill. I'm going to kind of get into the fiscal aspects of it. Again, I would certainly like a consideration of why this, once implemented, it's such a large ongoing annual cost. I can certainly understand upgrading the equipment initially and the initial costs, but after that, I would think it really should be in conformity with their existing equipment. So I just concerned that we're putting, again, additional burden on our local 911s. I would certainly also like, if it's a one-time cost, for the state 911 fund to fully fund it so it doesn't become a local burden. So, again, I certainly like to see the bill move forward, but I certainly would like even the full committee to consider some fiscal actions going forward.
I totally agree with him. I think that should be filled by the state, not the local. So we try to look into that and research that a little bit.
Absolutely.
Moving forward. Other questions, comments? Seeing none, we're voting on House Bill 173. Those in favor say aye. Aye. Opposed? Ayes have it. You're moving on to full. Thank you,
Thank
Molly.
you, Mr. Chair. Thank you, members.
Now we're on HB 0404 by Representative Carringer.
Thank you, Mr. Chairman. Would you like for me to go down front or here?
You'll be fine just where you're at.
Okay, thank you so much. And thank you to my fellow board members.
We have a motion, second. Okay, the bill's properly before us. Continue on, Representative Carringer.
Okay, thank you. This bill, House Bill 404, was brought to me by the Secretary of State, Library and Archives, and it's dealing mostly with our regional library boards. This legislation pretty much is about talking about our regional library boards that have existed since 1950s in Tennessee and was previously, these boards actively governed the regional library offices. However, in 1995, the employees of the regional offices became state employees. As part of the Secretary of State's office, that since that time, the regional library boards have not had any actual authority. Meetings of the regional library boards are held to comply with the law, but the boards do not conduct any official business. Rather, they operate more as sharing sessions where each member reports on library activity in their county if they know of any. So many of these regional library boards have long-standing vacancies, and the counties are having trouble to recruit board members to participate. The attendance is poor, and these members sometimes will travel as far as 70 miles for these meetings, and the members are reimbursed for travel expenses. So, and if they didn't have these, therefore we would be saving a decrease of our state expenditures by $8,400. So the Secretary of State was just asking that we no longer have these boards, and I have Mary Beth from the Secretary of State here if anyone has any questions.
Questions has been called. We're now voting on 469 by Representative Callender. 404. Those in favor say aye.
Aye.
Those opposed? The ayes have it. Bill moves on to full committee. Item number 6, 0469 by Representative Carringer. You are recognized again.
Thank you, Mr. Chairman. So today I'm bringing...
Have a motion and a second?
Oh, that's right. What's wrong with you, Carl? Wake up.
Okay. Bill's properly before us. Go ahead.
Okay, I've got House Bill 469, and this is dealing with the Treasurer Department, and it's talking about unclaimed property bill. And it's, the Treasurer Department hosts the state's unclaimed property and works to return the property to its rightful owners. The bill amends current law to reflect that federal law was recently changed to move the required minimum distribution age from 70.5 to 72. Dale, I don't know if that might get you in there. I'm not sure, but anyway. So current law requires that tax-deferred retirement accounts are presumed abandoned on the date a second communication is returned undeliverable, provided that the apparent owner has reached 70.5, or if the apparent owner is deceased and the IRS requires a distribution. 2 years have passed since the holder received notification of the death. The bill amends current law to remove the reference to a specific age and instead refer to the age by which the IRS requires a distribution, making the provision evergreen in case required minimum distribution age changes in the future. So I also have Roy West here with the Department of Treasury if anyone has questions. It simply is allowing the Department of Treasury to give the money directly if they know exactly who is the bearer to receive the monies. So,
You are recognized, Representative Bricken.
Thank you, Mr. Chairman. Again, the conformity with the federal laws and the IRS distribution rules, I have no question with. But Section 2, dropping the unclaimed property from $50 to $25, I think is not needed. It's not going to, I think, grab a lot of unclaimed property. If anything, it should go from $50 to $100. I'm not sure why the treasurer really wants to do this. I think it's just going to put an increased burden to the Treasury Department for this. It's the system's not broken. Certainly, in my banking experience for unclaimed property, I mean those reports are filled out, and I just don't think you're going to capture a lot by doing that. But you are going to bring some small businesses or some others into the equation of this. So again, I like this, if this bill goes forward, I certainly like to see Section 2 amended to be done away with. So.
Other questions, comments?
yes. So Roy West from Department of Treasury would like to speak, Mr. Chairman.
Okay. We'll go out of session. Please state your name and who you're with. Make sure your mic's turned on. Thank you.
Roy West, Department of Treasury, Director of Legislative and Agency Affairs. Thank you for the question. Currently, all businesses in the state of Tennessee are required to report any funds to the Department of Treasury for unclaimed property from zero to the maximum amount. This would just change the fact that they would have to provide us the contact information for those entities or for those individuals who own the money. Years ago, when we were in a paper-based system, it was a problem for holders to have to file all these little names on small dollar claims. And so this, now that we're in an electronic world, there's no future burden on these individuals or these entities, nor would it be on our department because the small dollar claims would be automatically claimed.
You are recognized, Representative Brigham.
So, of course, so currently everyone, when they file the annual reports of unclaimed property, the $50 or less are just down in a bucket of $50 or less without any identification. They're put on, I don't remember that, but So, I mean, without looking at a report, but you're saying those are just identified as unidentified, I'm bank, and there's $400 or $50 or less money that we have. We're not telling you the name and address of those. So now the bank would have to give you the name and address for those from $25 to $50, right? Is that what we're saying?
Thank you. Yes, sir. That is correct. Currently, the businesses have the discretion to report those dollar amount or that information at this time. And this bill would change it to where anything from 25 to 50 would be required to be reported with the contact information.
Again, I just think it's not necessary, but.
Other questions, comments? Thank you. We're going to go back into session. Committee have any other questions, comments? Motion's been called. We're voting on HB 0469. Those in favor say aye.
Aye.
Opposed? Ayes have it. You're moving on to full committee.
Thank you, Mr. Chairman.
We're going to transfer the gavel to this nice white-haired young man here.
So the red light's on, and we are now back in session. We're going to recognize our chairman, House Bill, item number 7, House Bill number 820. Chairman Holtzclaw, you're recognized, sir.
Got a motion, second?
Motion. We need a motion, and we do have a motion. We've got a second. You're recognized, sir, for an explanation of House Bill 820.
Thank you, sir. HB 820 is basically, it's an administration bill brought to me by the Secretary of State. It does a couple of things. It streamlines 2 departments to trying to make it better for the efficiency of the department. It's business and services and charitable solicitation and gaming. And they collect funds for this, and it goes in a big bucket, and this is going to allow them to use a percentage of that to defray the operating cost of the department. Also, they're going to do twofold things. It's going to reduce the current fees that they charge these charitable organizations. It used to run like $25. We're going to bring it down to 10. And then for businesses, it was anywhere from $250 to 50, and they're going to bring that down to 10 also. So they're reducing the burden to the citizens wanting to hold these events. With that being said, I renew my motion.
All right, the sponsor has renewed his motion. Looks like over in the Senate, it's coming up tomorrow to be voted on. So any questions, members, to the bill sponsor? All right, do I hear a call for the question? Yes, I just heard one, so I see no objections. Therefore, let us vote on House Bill number 820. Those in favor, please say aye. Those opposed, like sign. The ayes have it. And with that we're moving on to we're going to move on to the full committee. Duh, of course we are. So,
it's your committee.
We're going to go back out of session and return the gavel to our distinguished chairman, Chairman Holtzclaw.
Thank you, Chairman. And we're down to item number 12, which is HB 1082 by Chairman Carr. You are recognized.
Thank you, Mr. Chairman.
Got a motion and a second. Now, the bill's properly before us. Explain the bill.
Thank you, Mr. Chairman. In 2019, this General Assembly allowed for higher education to create a sports authority facility. Therefore, that way they could sell alcoholic beverages on the premises. And one of the things that they left out when they just classified facilities there or higher education, they left out the word private. So all we want to do is add the word or private into the definition to make state-supported schools legal, and also private institutions will be able to have this sports authority facility that they may be able to serve alcohol to. And it's permissive. It does not mean you have to have one. It just allows you to have one if you're a private institution of higher education. And with that, I renew my motion.
We do have a question. Representative Beck, you are recognized.
Thank you, Mr. Chairman. To the sponsor, would this mean for example, here in Nashville, that Vanderbilt, you could now have a drink during one of their football games?
Yes, sir.
And the way their athletics is going,
They need one.
we need a drink. That's exactly right. Thank you very much.
No comment.
Other questions, comments? Seeing none, we're voting on HB 1082. Those in favor say aye. Aye. Opposed? You're moving on to full, Chairman.
Thank you, Chairman. Committee.
And this will be the last item that we take up today due to time. And it's item number 13, HB 1359 by Chairman Marsh. Or I should say Speaker Pro Tem Marsh.
Thank you, Mr. Chairman. HB 1359 clarifies that retail food stores licensees, which are grocery stores, are not permitted from also obtaining a delivery service license for the delivery of wine and beer. Unlike other ownership prohibitions in law that protect businesses and consumers, current law is silent as to whether retail food store licensees, grocery stores, are able to deliver beer and wine with their own service or required to use a third party. In November 2020, the Alcoholic Beverage Commission proposed a rule prohibiting the owner of a grocery store who has a retail food license to sell beer and wine from also owning a delivery service that has a license to deliver beer and wine. What is happening is in Tennessee, grocery stores can now sell groceries and have them delivered to their customers. They can also deliver wine and beer. And they are also allowed to use a third party, a delivery service, to deliver the groceries or the wine and beer. What we're trying to do today is say that the grocery stores will have the authority to deliver their food and also the wine and beer. They're able to do it now with a third party. We just say bring it in-house and let them do it. And what I'd like to do today, Mr. Chairman, is I have Rob Eichard with the Grocery Association. I'd like to ask come up and say a few words. And then what we plan to do is to roll this bill and give us time to work on it.
Before we do that, you do have an amendment on the bill. You want us to put the amendment on the bill to get in it?
We can probably do that later. It'd be fine.
Okay.
You rather do it now?
Well,
let's go ahead and do it then.
If this is going to change, though, if this is the amendment he wants, so if he's going to change it, then we should.
Okay, we have an amendment 004412, is that correct?
Let me see. 4412, correct.
Okay. Do I have a motion second on the amendment? Okay, it's properly before us. You want to explain the amendment?
That does what the bill's trying to do. That says what the bill's doing.
Okay. Question's been called on the amendment. Those in favor of putting the amendment on the bill, say aye. Aye. Those opposed? Amendments on the bill. Now we're back on HB 1359. And there is testimony, so we'll go out of session. And first up, we'll have Rob Eichard with Tennessee Groceries and Convenience. Speak in the mic and state your name and who you're with.
Yes, Mr. Chairman, members, I'm Rob Eichard.
Before you continue, due to time limits, you got 3 minutes. So
Yes, sir.
be efficient and state what you want to state.
Yes, sir. Rob Eichard, Tennessee Grocers and Convenience Store Association. And as Speaker March said, this is a clarification that addresses a vagary in the alcohol law that does clarify that a wine and retail food stores license holder can also hold or have stake in a company that holds a delivery service license. Wine and retail food stores passed in 2014. In 2015, they came along and developed this delivery service license, which specified that third-party companies could deliver wine from grocery stores. Grocery stores have partnered with these third-party companies, and it's become expensive to continue to do so. And so grocery stores are developing a desire to go into the delivery service business themselves and deliver their groceries themselves. This is not just about wine with the business model they're contemplating. But wine is a grocery, is an item that they sell, and they want to be able to deliver wine as well. So this is simply just a clarification that they can hold both licenses. This is true for big chain grocery stores and for mom and pop grocery stores in Tennessee that are trying to figure out how to get delivery to their customers. Delivery was not a thing really when wine and retail food stores passed, and it's a big thing now, and we're just trying to clarify and keep up with the development in commerce. Some have called this an Amazon bill. I don't represent Amazon, and there are lots of grocery companies that are interested in getting their wine product along with grocery to everybody else. This does not expand access to alcohol in any way. If you look at the fiscal note, it confirms that. Wine from grocery stores is currently being delivered. It's just being delivered by a third party. And we would like our members to be able to have a company that delivers wine as well. The language on the amendment was developed in consultation with the TABC to make sure that we have it tied down just perfectly. I'd be happy to answer any questions that you all have.
I reckon the first question I have, we'd talked about wine specifically. I know grocery stores sell beer too. Is that also involved in this?
I think currently they can deliver beer, but this bill does clarify that delivery service company can deliver beer as well.
Okay, so it's those two spirits.
Yes, sir.
Other questions? You are recognized, Representative Bricken.
Thank you, Mr. Chairman. Certainly have been a lot of discussion about this bill. Something that I didn't ask earlier are, if I'm ABC grocery store and just want to deliver wine and beer, don't have a separate delivery company, can I do that?
You can't deliver wine, no.
You
would need a delivery service license to do that.
So you have to have another license.
That is issued by the TABC, yes, sir.
But ABC Grocery can't get a delivery license themselves? Do they have to form a separate entity as a delivery company?
They could get, the store itself could get a license, or there could be a separate entity that they have an ownership stake in that could get a license as well.
But I understand the current law wouldn't allow a separate company-owned delivery company. But if the grocery itself wanted to get a delivery license, could they?
The TABC's current interpretation of the law says that if that grocery store has a wine and retail food stores license, it cannot also have a delivery service license. This would remedy that.
Thank you.
Other questions, comments? Okay, we thank you for your testimony. I think we're going to also hear testimony by, no testimony? Okay, we'll go back into session. And you are now recognized again on HB 1359. Speaker Pro Tem Marsh.
I think what we want to do is roll this 1 week and try to make sure that we got everybody comfortable with it.
Okay.
if that's okay with you.
It is rolled 1 week.
Okay. Thank you, Mr. Chairman.
I need to correct myself. I said that we was running out of time. We do have a little bit more time, so we'll take up a couple more bills. I think you are correct. Okay. That brings us to item number 19, HB 1514 by Representative Cochran.
Thank you, Mr. Chairman.
We got a motion? Second, so you're ready to go?
Thank you very much. Yes, sir. This bill, currently the threshold for towns to be able to put liquor by the drink referendums on their ballot, that population threshold is set at 925. This just lowers that threshold to 700, giving more towns ultimately kind of control over their own destiny. And so they can decide whether or not they want to put that on the ballot. A lot of times you have towns that have small daily populations, but they may have a lot of tourism that flows through their town, and they have a lot of restaurants, but currently they're not able to have this type of vote. But I will yield for any questions. Thank you.
Questions, comments? Questions been called on the bill? We're voting on HB 1514. Those in favor say aye. Those opposed? You're moving on to full.
Thank you, Chairman and Committee.
I don't see Representative Doggett. So, I see. Yeah, I'll give you a few seconds to go get him. What about Representative Freeman? Who? We'll move to item number 23 while we're waiting, which is HB 1085 by Representative Hodges. Okay. We got a motion and a second, so you're well locked.
Thank you, sir.
Please explain HB 1085 to us, Representative Hodges.
Yes, thank you, Mr. Chairman. There is an amendment that makes the bill.
Okay. We got a motion and a second on the amendment. What's your drafting code on that?
004061.
Very good. It's correct.
I got that answer right.
Explain that amendment to us, please.
So what this does is allow for an entertainment district in Clarksville, kind of like you see in some other cities in Memphis and Knoxville and Chattanooga. So we're just going to be able to block off an area and allow for open liquor in that area during certain hours of the week. And with that, I'll be glad to answer any questions.
Questions, comments? Seeing none, we're voting on them. Oh, you got to stand up and wave there. We missed you. You are recognized, Chairman Key.
Thank you, Chairman. Just quick, Representative Hodges, did this require a resolution by the city council or anything like that?
No, so they're supportive. They didn't get it.
They are.
They actually asked. Yes, sir.
Okay,
They're supportive.
That's
And
all.
it's permissive by them, too. They're the ones that would give the hours and everything else of
Gotcha.
operation.
Thank you, Representative Hodges. Thank you, Chairman.
Thank you. Other questions, comments? Question on the amendment. We're voting on 4061. Those in favor say aye. Opposed? Amendment goes on the bill. Now the bill is properly before us. HB 1085. Question has been called. Those in favor say aye. Those opposed? Bill moves on to full.
Thank you, committee.
Now we're backing up. My buddies in the back there, Representative Freeman. Item number 21. We got a motion second. You're a pretty popular guy, so explain HB 674. Looks like we've got an amendment on it also. Is that
Yes, sir.
correct? What amendment number you got?
4457.
Got a motion and a second on the amendment. You want to explain the amendment to us?
Sure, and the amendment writes the bill. So this bill creates a new type of liquor by the drink license called the food hall for Assembly Food Hall at 5th and Broad in downtown Nashville. we've consulted extensively with the ABC and believe that this legislation is the best way to resolve a number of legal issues that prevent the Assembly Food Hall from operating. And I can go through some of the reasons. It's simply simplifying the enforcement of the alcohol laws regarding the eateries at this food hall, allowing the eateries to operate under one license, which would simplify inventory control, storage, and the delivery of the alcohol. It would allow the people there to freely move about the different venues, and we've discussed this with the ABC extensively, and they're on board.
Just for my knowledge, define a food hall?
It's a one large area where you've got multiple places that you can eat. Fifth and Broad right here. If you've driven downtown, you've seen it. Some of the restaurants that are in there, Princess Hot Chicken, the Pharmacy. It's going to be a great spot to go.
Multi places to eat.
Yes, sir. That's exactly right.
Yeah. Other questions, comments? Representative Bricken, I seen you in the plexiglass there. You are recognized.
Thank you, Mr. Chairman. Just a kind of a curiosity question. The movement of from patrons from businesses to businesses within the food court, I can understand that. What's going to prevent that spilling out on every public street, though? I mean, what are the provisions to keep that in line?
I can't speak to the specifics that they're planning on because it's not in operation yet, but I would assume, and
keep going, brother.
I would assume the same provisions that would operate any other business to keep them from leaving, likely signs. Any restaurant you go into downtown right now, they let you know. So this wouldn't change that law.
Well, I know that, but that's the food. I mean, that's going to be a much more open, accessible location to get out on public streets than just leaving an establishment. So it just seems like that somewhere is could become a problem.
You recognize?
If you think of the perimeter of the establishment as just expanding out a touch, it's the same exact concept. The only difference is you're going to have multiple options to eat. You still have ingress, egress. They'll still be responsible for making sure that they follow the rules of the city of Nashville.
No other questions.
Your Representative Carringer, you're recognized.
Thank you, Mr. Chairman. I just had a question. I know how we had this down on Cumberland in Knox County with the restaurants serving alcohol, and they always had to put up wrought iron kind of type fencing or barricades or whatever because it was out there on the street. So just what is going to be like for where this is going to be at?
It's an indoor facility.
Okay.
We're not changing the laws.
So they're not able to get outside and all with it. If they are, it would have to be in a perimeter that's blocked off for being able to get out, like where cars are going and all. I think maybe was your.
I thought it had open access to the.
No more so than any other place in town.
Yeah. Okay.
Other questions, comments? You're recognized, Representative Back.
Thanks so much. Sponsor, this sounds like it'll be a great addition to your district.
You are recognized.
No comment.
Wanted to also let you know on we had done something similar to this before on Hunter's Station, but we used the urban park designation by the ABC. So I was wondering, do you have any idea why you needed to come up with a new designation and couldn't use the urban park designation?
I don't, but I've got some people that might be able to answer that question if you want to.
Do we?
No, I don't think it's that important. But if you would find that out or check with ABC, I want to know what for future use in beautiful downtown Nashville, I wanted to know what the difference would be. Thanks.
You can go from Vanderbilt down to the hall, our Representative Beck.
Very good. Thank you, sir.
We're voting on Amendment 4457. Those in favor say aye. Aye. Opposed? Amendment goes on the bill. The bill's properly before us now. Question has been called on HB 674. Those in favor say aye. Aye. Opposed? You're moving to full, Representative Freeman.
Thank you, Committee Chairman.
And I did see, oh yeah, you got another one. I was going to back up. I got to keep going forward. HB 669, is that correct?
Yes, sir.
Do we have a motion second? Okay, does this have an amendment?
No, sir.
No, it does not. So you're ready to roll.
Thank you. House Bill 669 is a clarification bill brought to me by the Tennessee Distillers Guild. Currently, there is nothing in the TCA stating that the percentage for when a minority ownership in a distiller has to disclose that ownership, which is an annual requirement for license renewal. The Distillers Guild and the Tennessee Alcohol Beverage Commission work together on this legislation to make it clear that anyone who owns more than 10%, direct or indirect, must still provide the regular disclosures. The bill requires only the name and percent ownership of anybody who owns 10% or less of the distillery. Additionally, there is a need to clean up Section 1 in this legislation to fix an oversight in the 2019 privilege tax, removing legislation brought to the wineries that inadvertently impacted the distillery storage law.
Having that explanation, we have questions, comments? Seeing none, we're voting on HB 669. Those in favor say aye. Aye. Opposed? Bill moves on to full.
Thank you, Committee.
Now we're going to back up to item number 20, which I think is my buddy, Mr. Doggett. It's House Bill 1517. Got a motion and a second. And it does not have an amendment, so you're ready to roll.
Thank you, Mr. Chairman and committee. Members, what this bill simply does is creates a population exemption for a small town in my district to have a referendum for them to be able to sell alcohol.
Question's been called. Those in favor say aye. Aye. Opposed? Bill passes on the full.
Thank you, Chairman and committee members.
Item 24 by Representative Alexander, HB 0201. Got a motion on the bill, and it has no amendment, so you're ready to roll, Representative.
Thank you, Chairman. And committee, I appreciate you listening to this bill. This is from a bill that was from my hometown, historical Jonesboro, Tennessee, and the bill authorizes the sale of alcoholic beverages on-premises consumption at 5 locations in Jonesboro: the historical Jackson Theater, the Jonesboro Repertory Theater, the International Storytelling Center, the McKinney Center, and the Jonesboro Visitor Center.
We have questions, comments on the bill. Call for the question, HB 0201. Those in favor say aye. Aye. Opposed? Bill moves on to forward.
Thank you, committee. Thank
question. I was going to ask her questions. I'm probably not. I'll probably go to the next available calendar. Okay, we have one more item we'll take up. Is item number 25, HB 0682 by our wonderful Representative Beck.
Thank you, Mr. Chairman. I have a
Looks like-
amendment.
Yes, you do. Get it. We have a motion second on the bill. No, but you have to have it on the bill first, don't you? Yeah, right. We need a motion second on the bill. And now we're looking at Amendment 3820. Got a motion and a second. So now it's properly before us. Explain the amendment, Representative Beck.
Thank you, Mr. Chairman and committee. This is a amendment and a bill concerning the Mother Church of Country Music, the beautiful Ryman Auditorium, jewel of downtown Nashville. When there was a renovation done, the Ryman is under the Historic Performing Arts Center designation by the ABC. There's a conflict right now. After the renovation, the cafe, Lula's Cafe, was added, and it's open even when there's not a performance going on. So in order for them to continue to sell adult beverages, we need to change the designation and also allow them, there's a plaza area where they can wall off and have concerts and allow them to serve on that plaza area. I have two representatives from Ryman here if the committee's got any questions, but that was the sum of the amendment which makes the bill.
Motion on the amendment? Okay. Any discussion on amendment? Seeing none, we're voting on amendment 3820. Those in favor say aye.
Aye.
Those opposed? Ayes have it. The amendment goes on the bill, and we're back on HB 682.
The amendment makes the bill, Mr. Chairman. If there's any other questions, myself or my witnesses will be happy to answer.
Questions been called. Before we vote, you said they're in the audience?
Yes.
By
Nicole Watson and Will Cheek.
Glad to have you with us. That's a very nice venue. So let's vote. All right, we voted, right? We're going to vote on the bill, and this will make you all happy. Those in favor say aye.
Aye.
Those opposed? Ayes have it. Bill moves on to full, so you're one step closer.
Thank you, Chairman and committee.
The remaining items is going to be moved to the next available calendar. Now, a motion to adjourn has been entertained. We are adjourned.